Hi, I'm Dave Buckley. I'm a personal injury attorney. And often when I first meet with clients who've been injured and injured through no fault of their own, they often are speaking in terms of suing somebody. I'm going to sue that person who hit me. I'm going to sue that store that I slipped in. And while that's a common thing to say, um, filing suit is not what happens immediately. It can, given certain circumstances, but usually a lawsuit is not the first thing that a personal injury attorney will do when a person is injured through no fault of their own. Um, what happens first is if the person who caused you to be injured has insurance, we make a claim against the insurance company, and this is all after you've done your course of treatment and you're finished. A claim will be made against the insurance company. They'll be notified right away that we will be making a claim eventually on your behalf or the injured person's behalf. Um, but a lawsuit's not the first thing that happens. A claim is made, the claim is processed, and and if necessary, a lawsuit might result from that claim not being successful. And what do I mean by not being successful? Well, when I determine the value of a case, um, I have in the back of my mind what I think the value of the particular case is. I don't tell the insurance company, I want this amount of money or that amount of money. I just send in my demand. I provide them with the information they need to value the case. Um, and if they come back with a number that's close to mine, well, then I know that we can negotiate um, usually a settlement without having to file suit. If they come back with a number that is lower than mine, and by the way, they're never going to know what my number is. They don't need to know what my number is. I need to know what my number is to compare to theirs. But if they come back with a number that's lower than what I think the case is worth, um, I will go over the file with them. I'll say, well, listen, I gave you everything that you needed to value this case. What are you missing? Did you give credit for them going to physical therapy? Did you give credit for them having an MRI? Things of this nature. And sometimes uh, they have missed these things, and by adding in the things they missed, it does bring the value of the case closer to how I value the case, and we'll be able to settle it for a number that's appropriate for the circumstance. But sometimes there's no negotiating to a number close to what I think the value of the case is, in which case the only other alternative is to file a lawsuit, to sue the person who caused you harm, to sue that driver, to sue that owner of the dog, to sue that um, owner of the big box store, the big supermarket chain or whatever, um, and putting it in front of a jury and have a jury decide what the value of the case is. Um, and certainly that's a process. I mean, not all um, car collision cases, not all dog bite cases, not all slip and fall cases wind up having a suit filed. But as a personal injury attorney, as a trial attorney, I am always geared for litigation. Most personal injury attorneys I know are trained that way. You always, as an attorney, are ready to file suit if necessary. And again, if necessary. Sometimes you have to file a suit because you have to stop the statute of limitations from running. There are people who have head injuries, for instance, whose injuries are not resolved within a 3-year period of time, and you have to file suit to stop the statute of limitations from running so that you can continue with your claim. But just because you've been hurt by someone else's negligence doesn't mean you are automatically suing somebody. I hope that helps.